Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA, and my guest today is attorney Bill Mayhem, and we're going to be talking about short sales and foreclosures. And today we're mostly going to be talking about the mechanics of how this works. So, welcome, Bill. Thank you for being with me today.
Thank you, my pleasure.
So actually, in getting started, there's a lot of people that are actually renegotiating their mortgages. So before we get into actual short sales and foreclosures, let's talk a little bit about what happens with a loan modification.
Okay, let me say first of all that what we're talking about today is primarily involving residential property.
Okay.
This is a very complex area of the law, these modifications and foreclosures and short sales, and each case is going to be quite different based on its facts and circumstances. So we're just going to kind of be hitting the high points here today, but people really need to know this is complicated, and they should consult with a qualified accountant and or attorney before they actually do anything.
So get legal counsel. That's not what we're here for today. We're just want to give you some basic information that you can use as a starting point. But we really want you to go to an attorney and probably a tax consultant as well to get help.
Right.
Yeah. So let's talk a little bit about loan modification for a moment.
Yeah, loan modifications, a lot of people are talking about this. I get calls from my clients who are asking about this. Basically what happens is if you are having a hard time paying your mortgage payment, you can approach the lender and ask them about a modification. And unfortunately, this varies quite a lot from lender to lender as to how receptive they are to the idea. Some of them will do it. Many of them are not very receptive and have rules like they want you to be actually behind in your mortgage payment before they'll talk to you. Actually, in California, there's a statute that was passed recently that requires lenders to tell the borrowers in a single-family personal residence context before they actually foreclose on the property. They have to notify them of the availability of modification and at least talk with them about it. But whether or not they actually do it or not is dependent on a lot of circumstances. The lender, it's a voluntary thing on behalf of the lender, unless they've negotiated as part of some other transaction like happened with Bank of America when they took over Countrywide. It's basically up to the bank, and they look at criteria like the ability of the borrower to continue to make the mortgage payment, their relationship with the customer. So there's a lot of factors involved. But modification is, I think it's something people should definitely look into before they take these more drastic steps. But it's a little bit difficult to get the process going as well.
Yeah, there's a lot of people that are promoting this as, businesses that are sort of focused around this. Well, it's an opportunity because there are so many people that are in trouble. But I guess what it comes down to is there's no certainty. This is not a slam dunk that you're going to be able to do this sort of a thing.
No, it's not. It really depends on the lender. And there are sometimes circumstances. The federal government has programs where they've encouraged these modifications. And as I said, there's a California statute that makes the lenders talk to people about them. And I'm not saying they're not possible. They are being done. But it just varies a lot from one lender to the next and how interested they are, and also in the particular borrower and what their circumstances are.
Yeah. I've talked to some people, and they've expressed some frustration that, they tried to negotiate or talk to the bank, and then they said, well, I guess I'm going to have to do something else, short sale or foreclosure. Wouldn't it be better, instead of dealing with somebody you don't know, you know that I've made payments in the past, why not make a modification? But if they weren't behind, the bank just said, we're sorry, that's just not going to do anything.
And the irony of that is that people want to make these modifications because they're trying to protect their credit, and they're keeping current on their loan. Otherwise, they wouldn't be talking about a modification. You can't even talk about one. You shouldn't be able to talk about one unless you're continuing to make the payment, because your ability to pay has something to do with it.
Yeah.
But then when lenders tell you, well, we won't talk to you unless you're behind 90 days, then in order to get the talking going, you have to actually begin to default on your payment, and then that affects your credit anyway. So it's very confusing to most people, to myself included, how that works.
Right. Well, let's go ahead and start talking a little bit about foreclosures. And I think you and I have talked about this, that there's some confusion in terminology in California, that we have something called a foreclosure, but actually most actions are happening under something called a trustee sale. So could you tell us a little bit about how these are different?
Right. The term foreclosure really encompasses both. People talk about foreclosure, and they really are talking about both, but I think it's over 95% of all residential foreclosure actions are actually trustee sales. Mm-hmm. And the difference is a foreclosure, judicial foreclosure, judicial means you have to go to court. Mm-hmm. And there's a court proceeding whereby the lender gets the title to the property back. And then there may or may not be an entitlement for them to go after a deficiency judgment against the borrower, depending on the kind of financing that it is. But most lenders don't do that in California. Most of them proceed under the trustee sale provision, because when you buy a property, you sign a note and a deed of trust. And the deed of trust names a trustee who has the power to sell the property if the borrower, default in the payment. And the reason that is preferred by most lenders is because it's faster, it's cheaper. There's no right of redemption, meaning that once you've gone into the process, the borrower can't get the property back after the foreclosure is completed by trying to bring the mortgage back to being current again. So for a lot of practical and business reasons, the lenders tend to use the trustee sale as opposed to the foreclosure procedure. Mm-hmm. And it's almost entirely what's done in residential property in California.
Okay. So could you tell us something about what are the steps that a lender has to go through for the trustee sale?
Well, excuse me, again, it depends on the context of the transaction, but in the context of a single-family residence, owner-occupied residence, the process basically is that once the borrower is in default, not making the payment, then the trustee provides them with a notice telling them the property is going to be sold in trustee sale. You then get into this California statute that I mentioned before about having to at least notify the borrower about the availability of a possible modification of the loan. And then eventually there is actually a date for sale, and the trustee sells the property. It's sort of referred to as selling the property on the courthouse steps. And sometimes the lender takes the property back into their own inventory. Sometimes it's actually sold. But the point is the title to the property goes back to the lender through a trustee sale. Mm-hmm. And then other things happen after that, depending again on the type of financing that it was. But we're going to talk a little bit later about non-recourse and recourse and the tax consequences. But it doesn't necessarily end with that, but the procedure is fairly straightforward and fairly quick for the lender.
So